What I wanted to do in this video was go through a Labor Code Section 132A petition or claim. A lot of injured workers feel that they're discriminated against by their employer. You've been hurt at work. Oftentimes it was not your fault, and now you're having to go through the consequences. And somewhere within there, the employer takes action against you, and you feel that you're being discriminated against. The Labor Code includes a statute. It's 132A that deals with discrimination. It's not part of the normal workers' compensation case, so you have to file a special petition for 132A benefits to obtain those benefits. It's not just part of the application. Filing or sending a letter to the employer is not enough. You have to actually file a petition. But let's go through some of the requirements and an overview of what a 132A is. So if you look at the statute, basically an employer cannot discharge or threaten to discharge, fire, an employee for filing a workers' compensation claim or making known an intention to file a workers' compensation claim. So you tell your employer, I got hurt at work. I think I need to file a workers' comp claim. They can't fire you just for doing that. They can't take action against you for receiving a rating or an award. Those are a little bit less common. Usually what you see with a 132A is that you've been fired or some sort of other act taken against you because of filing a workers' compensation claim. So what can you get if you prove a 132A claim? You can get a 50% increase in benefits, but it's only up to a maximum of $10,000, so it's not a lot of money. You can get costs and expenses, but it's only up to $250, really not a lot of money. Where the real power of 132A comes in is that you can get reinstatement and restitution, essentially, or reimbursement for your lost wages or lost benefits. So if you were fired and you've gone without pay for a year, you can get reimbursed for those lost wages, and that's really where there's more leverage with a 132A. So that discharge or threaten to discharge language, can I give you examples? You bet. Make life a little bit easier here with a few examples of some of the things that employers have done which have found to have been discriminatory or in violation of 132A. Those include reduction of pay or in your job status due to filing a workers' comp claim or making known your intention, loss of seniority at your job, denial of a promotion that you otherwise would have obtained, loss of benefits, health insurance, something along those lines, or vacation pay at work, a refusal to reinstate you. So if they laid you off and then refused to reinstate you because you were released to work, but now they won't bring you back, that could be a 132A. A refusal to provide modified or alternative work if you can establish that they would have done so with or have done so with other injured workers. We'll look at that in just a minute. Loss of a bonus or a promised bonus, or detrimental transfer or refusal to transfer. Those are some of the examples of the discriminatory acts employers have taken against employees that have been found to violate Section 132A. So when do you have to file it? That petition for 132A benefits needs to be filed with the WCAB within 1 year of the discriminatory act. So if you're fired, you need to file that petition within 1 year of being fired. That's the statute of limitations. If you have your promotion, if you're denied a promotion based on filing a workers' comp claim, you need to file that petition within 1 year of that denial. So it's within 1 year. If it's a course of conduct that the employer is doing over time, then it's going to be within 1 year of the last event or the last occurrence by the employer that you'll need to file the statute of limitations. So what do you have to show that the employer did to establish your 132A? there's basically three things. We need to show the employer knew of the claim or the injury. So the injury was reported, or you reported your intention to file the workers' comp claim. Somehow we need to show, or you need to show, that the employer knew of the injury. You have to be able to show that you suffered adverse consequences. So that's the being fired, denial of a promotion, loss of benefits, that type of thing. So the employer knew, you suffered adverse consequences. And then the third element that you need to be able to show for a 132A is that you were subject to disadvantageous treatment or burdens that other employees were not. So one example that likely would not rise to the level of a 132A is if you had an injury, you reported your injury, and then your employer laid you off along with your entire department, 100 other employees, all laid off at the same time. You would likely be able to show the first two elements. You had an injury, the employer knew, and you had disadvantageous treatment, but you are in the same boat as all of the other injured worker or all of the other employees that hadn't had an injury. So there was no disadvantageous treatment to you based on what happened to other employees, because it happened to everyone. So those are the three things you need to show. It's Labor Code Section 132A. I'll provide a link down below this video for a sample petition. There's not a lot to the petition itself. You basically just need to lay out the facts of how you believe the employer violated 132A, and then that's going to be against the employer. That's not against the insurance company. So workers' comp, the benefits might be provided through one insurance company, but the 132A is going to be against the employer. That's a brief overview. If you have more questions on 132A issues, feel free to send us an email. We'll record a new video.